So having done my homework over lunch on I looked at Chinchulia, can I ask this, going back to your dissection of the relevant parts of the directive, why do you need to say that 27, 28 are incorporate procedural safeguard or safeguards in some senses, ground safeguards? Why can't you just rely on 30 and 31?
2 reasons, my lord. One, because the judge at first instance refers to Article 27(2) and Article 28.1.
Judge at first instance.
First tier tribunal.
Okay.
Judge.
Well, do we? Yes.
So we said that was right, and sound reasons for it. 27.2 and 28.1.
Yes.
And second, because as I say, concept of proportionality has a particular meaning developed through case law, codified in the CRD, and it has those sort of, I don't want to say bolt-ons, but it has a sort of more elaborated meaning about the individualised consideration, the need
But
to
isn't it 31?
Yes.
Expressly refers to disproportionate, uses that word,
Yes.
and refers back to the factors in 28.
Yes, so that would bring in a sense, 28
Yeah.
anyway, but arguably only if you're a public, it's a public decision based on public policy or public security.
So it occurred to me that you might be pinning it on what the FTT judge said.
Well, it's not just that. I mean,
You don't.
28.1, 27.2 do give you a bit more substance to what proportionality means in particular contexts. And they do require individualised consideration, which is very obviously a procedural protection. And
So you say the individualised assessment
yeah,
is not covered by 31, even with a reference back to 28?
No, well, we would submit it is.
Yes.
But of course, if we're there anyway, we don't need, as it were, to have to go through that particular hoop as well. If it's a decision taken on the basis of public policy, public security, you can go directly to 27 or 28.1. You don't need to go via.
It's just that going through, as you did, 28, the torturous, my word, process of identifying whether it was a ground or a safeguard, or possibly either or possibly both, doesn't look very clear, even in the hurly-burly.
Well,
whereas 31, which is what Chinchula talks about 31 in your starred paragraph 85.
Yes. I mean, one of the other things is that you have to read them carefully, because 28.1, which also, I think you've accepted we get anyway, I'm sure subject to anything anyone else says, but that's about an individualised assessment by the authorities before an expulsion decision is made. Okay, so it's not just enough that you've got an ex post facto appeal to the tribunal, but you get an ex ante factual consideration.
It's not just
and there are factors here, because in ECHR case law, for example, the court will just look at the outcome of the decision. So you could have a non-individualised consideration, and if that deportation is proportionate, there's no need for individualised consideration. So
I've omitted to bring my notebook in case you think I'm texting somebody else. I'm just texting my clerk and asking her kindly to bring it in.
So, 28. What you say, 28.1 would require, before taking what the Secretary of State calls the Stage 1 decision, would require an individualised assessment prior to that Stage 1 decision.
Yes.
And also, just to understand a bit better what you mean by individualised assessment, is it one aspect of what I think you're pulling out of 28.1 is specifically how long they've been in the country, how well integrated they are, which give you, if you like, some parameters or guidelines for conducting a proportionality assessment that you wouldn't otherwise have.
So, just very quickly finish up with the upper tribunal's judgment. Although, as I say, there's a question of law, so it doesn't matter really. But we're either right on the law, in which case the upper tribunal is wrong, or not. Paragraph 67, essential thread of the reasoning of the upper tribunal was that
Here it is.
if you read Article 21 as importing what they call substantive safeguards, it renders irrelevant the distinction between Articles 20.1 and 20.2. So you see the reference in the first sentence to importing domestic substantive safeguards, and then in the middle of that paragraph there's a sentence that says to do so would render the clear intended bright line in relation to the approach for those who commit offences prior to the specified date and those who commit offences after. Pause there. Not necessarily offences that Article 20 is dealing with, but this is the framework that they're using. Irrelevant. That was clearly not the intention of the parties to the withdrawal agreement. Well, it doesn't render the distinction irrelevant for the reasons that I've given you. The distinction remains important. So that's driven them to this mistake. And there's also, of course, reference there to the assumed intentions of the parties, which is an approach to interpretation which is said to be not the correct approach in AT. One looks at the words and their meaning and not what we assume parties were bargaining for. So they're the core errors in the upper tribunal reasoning. In relation to the first instance tribunal, I don't want to say much. In our submission, it's clear that the judge is not importing, for example, 28.2, refers to 28.1, 27.2, and she's just doing an ordinary proportionality balancing assessment, and not intruding into the different grounds, as it were, the heightened grounds of public policy that are set out in, for example, 28.2. And we say that's entirely in line with what we say is the correct analysis. Can I then turn to ground 1 and the restrictions on rights? And if you still have the upper tribunal's judgment open, can we see the point that we're appealing against, paragraph 81? The decision under challenge before the judge is a stage 1 deportation decision. The wording is important. It was not a deportation order, but a notice advising Ms. Vargova that the Secretary of State had made a deportation decision against her and allowing her a period within which she was able to raise objections to the making of deportation order. We find it therefore not a decision which restricts her rights of residence. And that concept of rights of residence is, of course, from Article 21. We find on a proper interpretation of Article 21 that the safeguards in the directive have no application for the making of a stage 1 deportation notice stage or any appeal against the same. The question at that stage is whether the decision to make the deportation notice is lawful and under the applicable domestic regime. It's not a decision to remove the recipient of the notice, but a decision to consider making a deportation order. Now we say there are a number of errors in this passage, just as a matter of, as it were, domestic law, before we get to the withdrawal agreement. First of all, can I sound a note of caution about this concept of stage 1 and stage 2 decisions? This is a practice that is, as it were, grafted on to the legislative regime, and it isn't reflected, as it were, in the law, and it can be misleading. I'll explain why. Secondly, the upper tribunal in this passage characterises the decision that was made by the Secretary of State as, firstly, a decision to consider making a deportation order. That's the very end of that passage that I read out. A decision
Had made. Line 3 of paragraph 81, the Secretary of State had made a deportation decision.
Yeah, deportation decision.
Yes.
But at the end, it's a consider making a deportation order, and a decision to make a deportation notice, and it said that there's an opportunity to raise objections. Now, in fact, as I showed you in the UK Borders Act, once a person is recognised as falling under the conditions, either condition 1 or 2, in section 32, a deportation order has to be made, subject, of course, to exceptions. It's not a discretion. There's no discretion in it. Turn it back up again. Let's have a quick look in Authorities Bundle, page 78. There's a definition at 32.1, foreign criminal. You then have your alternative conditions. Then subsection 4, a person is deemed, their deportation is deemed conducive. And then at subsection 5, the Secretary of State must make a deportation order. Now, the Secretary of State can decide when to make it, but they must make the deportation order. So this is not, as it were, a provisional decision that's been made by the Secretary of State. It is not a decision to make a deportation notice. Of course, it isn't informed by notice. Nor is it a decision to consider making a deportation order. It's an incorrect characterisation of the decision.
Well, but does that factor in the provisos which are created by section 33?
So you have provisos, and this must be, of course, what the upper tribunal has in mind. But a number of points to make about these provisos. It may be that nobody makes any representations. So they may think, well, none of the exceptions, I'm not going to be able to make good any of these exceptions. I'm not subject to a wardship order. I'm looking at the case law, I'm not going to make good an Article 8 case. So you don't make anything. And in that situation, by operation of law, the deportation order has to be made. There's no further step. Even in relation to the exceptions, they're not discretionary exceptions. It's not that one has, as it were, an open-ended opportunity to persuade the Secretary of State not to make a deportation order. You can't say, Secretary of State, well, I think it would be very unjust for you to make a deportation order because I've donated lots of money to charity or something. But you don't have, it's not general discretion whether to make a deportation order. It's simply some exceptions which you're either inside or you're not. And if you're inside them, then the deportation order can't be made.
It doesn't. The exceptions don't depend, do they, on the individual raising them? The Secretary of State has to take them into account.
And that was the next point. So the Secretary of State has to consider them in any event before notifying somebody that they're within the terms of Section 32.1.
The scheme seems to be that for certain categories, those that are foreign criminals who don't come within any of the exceptions, there's a compulsory requirement to deport.
Yes.
But those who do, those foreign criminals who do come within the exceptions, there's the discretion reserved by subsection 7 of 33. Discretion is probably the wrong word. Well, that reverts to the normal test, if I can use that phrase.
That's right. That's right. So you could you come outside the automatic regime, but you're still within Section 3 of the Immigration Act.
Yes,
of course. But we're concerned with the operation of 2007 regime because that's the decision that's been made in respect of my client. But my lord is right that if the Secretary of State is aware at the time of notifying someone that they fall under this automatic regime of that in fact an exception applies, Secretary of State could not
Automatically.
automatically deport. So if, for example, there's information there that their person is subject to a wardship order or some of the other provisions where the Secretary of State might have on file, he might be able to look at his file and know that, in fact, they fall into one of the exceptions. And you saw in the letter that I took you to at the very beginning, where the Secretary of State says, you've not told us that you fall into any exceptions. That's at page 200. End of the first paragraph. You have not shown that any of the exceptions apply to you. Now, as a matter of practice, and good practice, no doubt, the Secretary of State allows someone to raise the possible application of the exception after they've been notified, and of course, they'll take that into account. But that doesn't change the character of what's going on here, which is that if you fall within the legal parameters, the deportation order has to be made, and if you don't fall in an exception, and you can't show that you do, the deportation will be made, the deportation order will be made effectively as an operation of law.
So really section 32.5 imposes a qualified duty on the Secretary of State to make an order because section 33 provides that section 32.5 doesn't apply in certain cases. So the Secretary of State has got to think about the exceptions in order to know whether or not he or she can make a deportation order.
Yeah, I mean...
So it's not an absolute duty, it's a qualified duty.
Well, it's an absolute duty if you're not within one of the exceptions.
Yeah, well, so I mean, it depends on which stage you're looking at.
Yeah.
But if your starting point is just looking at the statute, the effect of 32.5 is to impose a qualified duty because before the Secretary of State just can't automatically make a deportation. The Secretary of State's got to think first: does one of the exceptions apply? Because if one of the exceptions applies, then the duty in 32.5 doesn't bite.
Well, it doesn't tell you anything about the timing of that consideration. It's at least conceivable that the Secretary of State could do all of their thinking before notifying somebody under this section. The Secretary of State chooses to do this thinking afterwards. But if somebody chooses not to make any representations, and you get that from page 203 of the decision notice,
Yeah, sure.
then it would simply be made as operation of law. Now, can I just show you, well, in relation to Article 21, a restriction on a right. A legal right is obviously an intangible thing. It does not require a physical constraint in order to be restricted. Okay? The right here is the right to reside under the Withdrawal Agreement, and we know from AT that that right is not, as it were, a freestanding right, but is actually a manifestation of the Article 21 Treaty on the Functioning of the European Union right to move and freely reside. And I've taken you to those passages, which I rely on for these purposes. There is, however, one other point that I just wanted to point you to in that authority, which is that the court also makes clear that that right is being drawn from the CRD, because the CRD obviously gives further effect to Article 21, and that is the one point which I didn't show you on the way through. I'm sorry about that. It's at page 690 of the authority fund. Sorry, 710 of the authority fund. Now here the court is talking about general principles of EU law, but it makes the point, as it made in relation to Article 21 at H near the bottom of the page, that the CRD, which is also incorporated by cross-reference into Article 13. So just under the quotation, little h on the right-hand side. So the right that's being restricted is a right that has its origin in Article 21 and that's then given effect through the CRD. Now, if you can turn to tab 46 of the authority bundle, which is the case of Bouchereau, in the second bundle of authorities, this was a case which concerned a recommendation for deportation made by a court in this country.
Sorry, which tab?
46. So it wasn't even a decision to make a deportation order. It was a stage before that. It was the recommendation of a court. And it was only a recommendation. And the question in this case was whether a recommendation for deportation made by a national court of a member state is a measure interfering with free movement rights for the purposes of what is now Article 27 of the CRD. And you can see the relevant provision of the directive as they then were at paragraph, so there's no paragraph number, it's at page 1026, 1026, at the top of the page. This is in the Advocate General's opinion. Sets out the two paragraphs of the directive, which were different provisions because it was the predecessor directive. Measures taken on grounds of public policy or public security shall be based exclusively on the personal conduct of the individual concerned. Previous criminal convictions shall not in themselves constitute grounds for the taking of such measures. So you can see that's essentially exactly the same as Article 27 of the CRD. And the court addresses the issue raised at page 1045, at paragraph 6, near the top of the page, sets out the question asked. And then at 7, the question seeks to discover whether a court, which under national legislation have a jurisdiction to recommend to the executive authority the deportation of a national of another member state, such recommendation not binding on that authority, must, when it does so, take into account the limitations resulting from the treaty. Emphasise those words, the limitations resulting from the treaty and from the directive, on the exercise of the powers which in that area are reserved for member states. Then, if we turn to the relevant parts of the reason, if you look at paragraph 20 on the next page, the first aspect was whether, the two aspects, the first was whether a court was essentially bound by the directive. We don't need to worry about that. We're concerned with the second aspect of the question. Paragraph 20, as regards the second aspect of the question, the government of the United Kingdom submits a mere recommendation cannot constitute a measure within the meaning of Article 3. 21. For the purposes of the directive, a measure is any action which affects the right of persons coming within the field of application of Article 48 to enter and reside freely in the member states under the same conditions as the nationals of the host states. Article 48, I think, was Article 27, became Article 27. No, sorry, 21. Article 21 of the Treaty on the Functioning of the EU. Within the context of the procedure laid down by Section 3.6 of the Immigration Act, the recommendation referred to in the question raised by the National Court constitutes a necessary step in the process at arriving at any decision to make a deportation order and is a necessary prerequisite for such decision. Moreover, within the context of that procedure, its effect is to make it possible to deprive a person concerned of his liberty, and it is in any event one factor justifying a subsequent decision by the executive authority to make a deportation order. Such a recommendation therefore affects the right of free movement and constitutes a measure within Article 4 of the directive. Now we say this is essentially dispositive of this issue because we rely on all of those reasons, all of which apply a fortiori in our case, because this is a necessary step. It's also a decision that would have to be relied on in making a deportation order, and so forth. And if this is affecting the rights of free movement, as found paragraph 24, and is a measure within what is now Article 27, it must be a restriction on the rights to reside under the withdrawal agreement. And one has to read those coherently, it would not make sense otherwise.
Miss Smythe says there's a world of difference between a recommendation by a court and what she characterises as a stage 1 decision.
Well, I think we are well beyond a recommendation of court. We have a mandatory requirement to make a deportation order. This is not a recommendation. It's not a decision, even a decision of Secretary of State. It's a requirement of law.
So you say this case is a fortiori.
Leeway. A further point that's made by the court there is that it triggers a right to detain. A deportation order triggers a right to detain, and of course that remains the case. And there are two.
Sorry, you say deportation order. Do you mean a
sorry, decision. I'm quite sorry.
Service of a notice of intention to make a deportation order.
Yes, I'm so sorry. It's not a notice of intention to make. It's a decision to make.
Yes, sorry.
Notice
service of that decision triggers the right to detain.
Yes.
Okay.
And that's I showed you it's under Schedule 3. That's in the authorities bundle at 36.
Yeah.
And where somebody's already in detention and we're in the scope of the 2007 Act, there's an alternative power to detain, which is in Section 36 of the 2007 Act, which I also showed you. Maybe we should just briefly have a look at that.
Yeah.
So I think there are alternatives. My understanding is that my client was detained for a period of days. That's in the note, which we'll look at in a minute, scheduled to the upper tribunal's decision was under Schedule 3. But there's this alternative power here in Section 36, at page 82. A person who has served a period of imprisonment may be detained under the authority of the Secretary of State, while the Secretary of State considers whether Section 32(5) applies, and where the Secretary of State thinks they do apply, pending the making of the deportation order. Now, I think the point is made, well, that doesn't exactly correlate with the decision to make the deportation order, because actually you can detain a little bit before you've decided whether the provisions apply. But that's, in any that's a helpful solution.
Yeah, no, exactly.
So,
And just factually, because I think the original decision was served while client was in prison, but you say obviously that doesn't assist the Secretary of State because it affected her position on release.
Yeah.
Or provided an additional reason to detain her.
Yeah, exactly. So if we just, and there's another point you would have seen that's been made, although we submit we don't need it, which is in relation to the home detention provisions, which there's an agreed note on this that was produced for the upper tribunal, and it's actually scheduled, as it were, to their decision. And it's at page 164. Note on home detention curfew.
Right, I'll skip that up.
164.
Yes.
So if you look at paragraph 4, 5 and 6, there's references to the Criminal Justice Act, which allows the Secretary of State to release on licence under this section a fixed-term prisoner in certain circumstances. And then section 246, subsection 4, paragraph 5, states that subsection 1 does not apply where, amongst other things, the prisoner is liable to removal from the United Kingdom. And then point 6, further provision, for the purposes of this chapter, the person is liable to removal if he is liable to deportation under section 3.5 of the Immigration Act and has been notified of a decision to make a deportation order. I think over the page you get, yes, at point 9, you can see that Ms. Vargova was detained for a few days and then released on bail. But of course, being released on bail is also a restriction on free movement. Now, I showed you that there is an appeal at the stage that a deportation order is made. Can I just remind you of that? It goes to the appeal regs in the Authorities Bundle 1.
I just have an eye on the clock, Mr. Hickman. I think we've more than corrected the afternoon.
I'm planning to finish before 3 o'clock, and then we'll,
All right, good, fine.
We're all on time to do that.
Yeah, that's right.
All right, 3 o'clock. Now, where did we go to for the appeal regs?
The appeal regs are tab 18, page 159. And if you look at page 163, the right of appeal against the decision to make a deportation order.
Yes.
And we've looked at this, and you will recall, if you look at the grounds, so it's an appeal against the decision to make a deportation order, with the ground with breach of the withdrawal agreement, 8.2. Now, if in fact a decision to make a deportation order is not a restriction on your right to reside under the withdrawal agreement, it's impossible to see why you would have an appeal from a decision to make a deportation order. It would appear to be nothing to appeal. You would have to wait to some later stage in the process before you would have an appealable event or decision under the withdrawal agreement. But then that runs into the further problem that there is no further appeal. The only appeal you have for breach of the withdrawal agreement is this one. So you don't have an appeal at the point that a deportation order is made. So it's this or nothing. And we say that Parliament has clearly, correctly understood that this is the point at which you ought to have an appeal, no doubt by reference to the Bouchereau case that I have shown you.
Well, I guess it's the Secretary of State because it's regulations.
Regulations, okay, proved by
Yeah.
negative resolution. Yeah.
Well, it says approved by both houses.
Well, and also, yes, I think there's a point under the statute as well, isn't there? Because the 2020 Act. Oh, Mr. Bewley says he's going to cover that, so I'll let Mr. Bewley cover that point. So we say it's very difficult to understand on the Secretary of State's case at what point the Secretary of State says you would have an appealable decision under the withdrawal agreement and how you would go about exercising that right. And we say everything points to the decision to make a deportation order being a restriction on rights.
One can at least infer that the draftsman thought that
Well,
the decision was a restriction.
I'm not sure I rely on it as a particularly strong aid to interpretation of the withdrawal agreement, but it's certainly an anomaly of a rather large variety if the Secretary of State's right on the interpretation of the withdrawal agreement. And we further submit that if were that to be the case, as it were, if there's not yet been a restriction on rights, but that will come at some later point, and we don't exactly understand when it would be, but if it did come at some later point, that does not prevent Parliament from having an appeal at this stage and deciding, or the Secretary of State regulations, deciding that this stage is the appropriate stage to ensure that it's sufficiently protective under the withdrawal agreement, the obligations under the withdrawal agreement, to have an appeal at this stage. And if that's the case, well, then we're entitled to rely on the fact that a breach of the withdrawal agreement, if it hasn't yet actually occurred, is going to occur through the ordinary train of things. So that's my submissions on ground one.
Quickly look at the grounds of appeal again.
Yes.
The grounds of appeal are that the decision breaches any right, blah blah blah. And so the draftsman has at least assumed that the decision might breach.
Yes,
right.
That's the way you have to be, giving it purposive construction. And why not have an appeal that's protective? If you're not completely sure exactly where the restriction on rights is going to arise, you give people an appeal at a stage that's deemed appropriate under the domestic regime as it then stands. And there's nothing wrong with that, we say.
I mean, it's quite difficult to use regulations, domestic regulations, to interpret the withdrawal agreement. But is there a broader point that it just doesn't give effect to the ability to appeal that's specified, that's stated to exist under the withdrawal agreement?
I'm sorry, my lady, I'm not sure.
You mentioned using these regulations as an aid to interpretation.
Yes, well, I
I'm
did
not
push
really
that
sure
particularly strongly. Yes,
I'm not sure they are.
No, at best, all it might show is what the Secretary of State thinks is going on.
And also my, as it were, the other point that I've just made, which is that, well, even if there hasn't yet been a restriction, why, the clear intention of this regime is that we're able to appeal at this stage.
Well, that was my point.
Yes.
That there should be, the withdrawal agreement makes it clear that there should be a right of.
Well, there has to be. There has to be a right of appeal. Yes, absolutely, there has to be. And it's been this is the point at which it's been regarded as appropriate. And on the Secretary of State's case, as far as we can see, would empty this appeal right of any substance. So finally, reference to the CJU. This court has a power to refer the issues arising on this appeal to the CJU, if it wishes to do so. Article 158 of the Withdrawal Agreement, which is at page 157, gives this court that right. Perhaps I can just ask you to read the first paragraph from 158.
Sorry, I missed where we're going to next. My fault.
158 of the withdrawal agreement.
Well, so it's, yes, 158 of the withdrawal agreement. 157, page 157 in the
Thank
author's
you.
number. So if an issue of withdrawal agreement law is raised under Part 2, and if this court considers it necessary to enable it to give judgment to decide that issue, to which the answer in this case must obviously be yes, then the court has a discretion, may, to refer the matter to the CJU. And we suggest that there are good reasons for this court doing so, and I'll make the following points. First of all, the issue as to whether member states and the United Kingdom are constrained by anything other than the barest procedural protections in restricting the rights of persons exercising withdrawal agreement rights is a matter of very, very wide public importance, not only in this country but across the EU. Secondly, there is self-evidently an arguable point of law. We already have judgment, first instance, and the appeal judgment, the upper tribunal, which take different views, and we're here before the Court of Appeal arguing it. So there's self-evidently an arguable point of law. Furthermore, guidance was issued by the Commission does not support the approach of the upper tribunal. I'll just take you to that because we haven't seen it yet. It's in tab 61, bundle 2 of the authorities bundle. Now, this is not an official Commission note. It's been produced by officials at the Commission to guide member states. It's 146, tab 61. And you can see, first paragraph, this guidance note is purely informative, does not supplant or complete the agreement. So forth. Whilst this guidance note is being prepared by staff of the European Commission, the views contained in the guidance notes should not be interpreted as stating an official position of the European Commission. Okay, but the point is that this is being promulgated by the Commission. It's clearly designed to coordinate and guide the views of EU member states. And what it says about Article 21, if you turn to page 1482, and the relevant bit for our purposes is really the last paragraph under section 2.9, where it says, in line with the CJU's established case law and the general principles of EU law, restrictions decisions taken in accordance with national legislation, that's under 20.2 obviously, must comply also with the principle of proportionality and fundamental rights, such as the right to family life. So not only is there an arguable point here, but there is guidance that will be relied upon by member states, which takes a different approach to the approach of the upper tribunal in this case. Next, Article 4.1 of the agreement, as we've seen, sets out a principle of consistent effect. So the agreement has to be given a consistent effect throughout the EU and the UK. And this court is itself subject to the obligation to promote that through Article 5, not just Article 4, as we've said. You have to consider how it would be interpreted in EU jurisdictions, but Article 5, which we haven't looked at, 139 of the Withdrawal Agreement, the Union and the United Kingdom shall, in full mutual respect and good faith, assist each other in carrying out tasks which flow from this agreement. They shall take all appropriate measures whether general or particular, to ensure fulfilment of the obligations arising from this agreement, and shall refrain from any measures which could jeopardise the attainment of the objectives. Now, carrying out tasks which flow from this agreement, this court is carrying out a task which flows from this agreement, and it therefore is subject to a duty to assist the other member states to reach a consistent effect and a consistent meaning of the agreement. It is required to take appropriate measures to ensure fulfilment of the obligation. And when you read those provisions, together with Article 4.1, together with the Commission note, which we've just looked at, in my submission, there is a compelling basis here for making a reference to the CJEU.
Can you just talk us through again the status of the Commission note?
The only thing I can tell you is what is said on the facing page of that Commission note, which is that it's been prepared by the staff. It's not the official position of the Commission, but it's clearly been promulgated in order to assist member states. Member states will place reliance on it in applying the withdrawal agreement, just as we would if there was guidance promulgated by the government. What it shows you, at the very least, is that there is a real risk that there's going to be divergent approaches taken in different jurisdictions. And of course, the CJEU, although it's an EU court, is the authoritative source of interpretation of this agreement. That's why there's that reference power. And of course, it's the authoritative interpreter of EU concepts and of EU law, including the CRD. And I referred you to paragraph 23 of Lumsden, where the Supreme Court says it's the authoritative source of interpretation on proportionality as a matter of EU law. That's it, Authorities Bundle, tab 26, page 298. Lumsden, paragraph 23. So, for all those reasons, we do say that there is a compelling case for a reference. Certainly, if you're even minded to accede to the submissions made by the Secretary of State, a reference ought to be made in our submission. We have one other ground which relates to the preserving of facts at first instance, but in light of the Secretary of State's Scale of 9, which we've been considering very carefully and what's said there, we don't think there's any need to address that point.
Thank you.
Unless there are any questions, those are my submissions.
No, thank you very much, Mr. Hickman. Very helpful. Now, Mr. Booley, you're going next.
I am, my lord. I'm just going to get the lectern. That's right. Great. Stick around there. Give you one moment. My lord and my ladies, if it's helpful to know, I think the only file I'm going to need you to look at is volume 1 of the Authorities Bundle. It may be useful to know. So, my lord, my client, the Air Centre, has permission to intervene in the Vargova appeal, not strictly speaking in Molnar, which is one of the reasons I'm going next. As we've said in Skeleton, we didn't have anything to say on what was ground 4, and in fact it turns out you haven't heard anything about that in any event. On ground 3, so the reference, we support the position of Mr. Hickman, but I don't have anything to add. Adopt what he says. So that leaves ground 1 and 2, or issues 1 and 2, as to which I can again adopt his submissions. And I say that in particular because paragraph 9 of the Secretary of State Skeleton says that, if you like, those on this side of the room, those supporting the appeal, adopt all sorts of inconsistent and different approaches. We don't accept that that's right, but I say expressly that I adopt Mr. Hickman's submissions. What I hope to do is to provide some additional points which are entirely consistent with his arguments and which go further to support them. And I'll take the issues in the numerical order, not the order that Mr. Hickman took them. So ground 1 first, ground 2 second, issue 1 first. So ground 1 has been called in the appellant skeleton the restrictions ruling. So this is, in other words, the question of whether a decision to make a deportation order, the decision that was appealed in this case, is a decision restricting rights within the meaning of Article 21 of the Withdrawal Agreement, which we see on page 150 of the authorities, although you may not want to turn it up at this stage, because you'll have seen it obviously a number of times already. So, essentially 3 sets of points. First of all, I would emphasise, and I said I didn't want you to turn it up, so you can take my word for it, but you might want to have it up for this. It is important that the language of Article 21 refers to a decision that restricts rights. Not as such to a restriction of rights, but to a decision that restricts rights. And in terms of the domestic statutory scheme, there are really only 2 candidates for such a decision. That's to say there are only 2 places where the Secretary of State makes a decision. The first, and we say the right one for our purposes, is the decision to make the deportation order. The only other one, and I'll come to the legislation on this slightly further down my submissions, but just have it in mind at this stage, is the decision to refuse a human rights or asylum claim, which then gets a right of appeal under Section 82. But neither of those those are the only 2 matters that are candidates for the decision referred to in Article 21 in our domestic scheme. And just to kind of revisit, I hope without trespassing, but very briefly, a debate that the Court was having with Mr. Hickman just a moment ago. If you just think about, because as you've picked up, and I don't want to go through all of the legislation again, there are two ways you can get a deportation order. You can get it under the mandatory scheme, or if that doesn't apply, there can be a discretionary decision. What I say about the first will apply, but I won't go through it for the second. Just think about the first of those. So as the Court has seen, when what the Secretary of State does, applying the provisions of Section 32 and 33 of the 2007 is consider whether the conditions apply which mean that you have to make she has to make a deportation order. So first of all, is this person a foreign criminal? And that involves things like, is it 12 months and so forth? And secondly, do any of the exceptions apply? And if there's no discretion, I mean, it may be that some of the exceptions involve an element of what might be called discretionary judgment, but if the conditions for making it apply, so the conditions, you are a foreign criminal and none of the exceptions do apply, then the Secretary of State has to make a deportation order. And the deportation order itself, as I understand it, there's no doubt that restricts rights when it takes place.
Sorry, the deportation order.
When the deportation order itself is finally made, but as between the decision, the Section 32, 33 decision, and the making of the deportation order, there is no further discretion. All that happens, and because of time, I don't particularly want to take you to the provisions on this, but can I just tell you the legal position for now? All that happens is that by virtue of various provisions, the actual making of the deportation order is suspended, or its effect is suspended, and it can kind of slightly vary depending on which regime you're in, while you go through the appeal process and or make your human rights claim. But the decision that you will do it has been made at that stage, subject only, and I'll come on to this, to the human rights claim. So that is, if you go back to the language of Article 21 in my submission, that is a decision that restricts rights. And the only kind of line between that is the suspension of, because you can't actually make the DO until you go through the appeal process.
What rights does it restrict?
Well, the deportation order takes away your right of residence and so forth.
You know, what rights?
No, sorry. So I accept.
What rights does the decision to make?
Deportation order? I know this is not what my lord asked, but let me. So the deportation order restricts rights. That's clear. But the only decision that you make is the decision at the earlier stage. All that happens under the statutory scheme is that the effect of the decision, i.e. the actual making of the deportation order, is suspended pending the appeal. But there's no further decision for the Secretary of State to make once the appeal rights are all exhausted. it just, and the Secretary of State by that stage has a statutory duty to make the DO.
Okay, so you don't characterise the deportation order itself as a decision.
Exactly, it's not.
Because
there isn't.
you say
Yeah.
it just follows.
Exactly. All of the decision making that the statutory scheme allows for is made at the stage of what we're calling the decision, what the statutory scheme calls the decision to make the deportation. All of the decision making occurs then, save only for human rights, which I'll come back to in a minute. And so if you go back to the language of Article 21, that is the decision that restricts the right. Notwithstanding that, as I accept, some of the actual restrictions don't get suspended. And on any view, and this leads really into my next point and also into a discussion that Paul was having with Mr. Hickman a moment ago, the Secretary of State would be, I should say Parliament, because it's more, as you will see in a minute, it's more than just the Secretary of State, would be entitled to set up the statutory scheme in a way that treats that as the decision that comes within Article 21. But that's my first, if you like, set of points, point or set of points. Secondly then, and this is the point that Mr. Hickman started on and then, I'm grateful, left to me. Mr. Hickman made to you a point about the 2020 regs, but there's a prior point to that under the primary legislation. So if we go, please, to page references, I want section 11 of the EU Withdrawal Act 2020. So it's Authorities tab 15, page 121. Page 121 of the Authorities, that is.
Yes.
So this is section 11 of the EU Withdrawal Act. So this is the legislation which is enacted by Parliament to give effect to and implement the Withdrawal Agreement. Pick that up, I think, already. And this section is the vires for the appeals regulations, which Mr. Hickman has already taken you to. And if we look at it, therefore, section 11, 11.1, a Minister of the Crown may, by regulations, make provision for or in connection with appeals against and this is defined, citizens' rights, immigration decisions. I think Mr. Hickman did take this provision, but I didn't make the point I'm now going to make. And there was a question about what's the definition of citizens' rights, immigration decisions,
Yes.
and the definition is given in subsection 2.
Yes, I remember.
And indeed, if we then look down, so F, the critical ones for our purposes are F and G within subsection 2. F, a decision to make, and it goes on to say refusal to revoke, I mean, ... if you like, we don't need to worry about that for present purposes, but the same analysis would apply, I think. A decision to make a deportation order under section 5.1. So the reason the Secretary of State has vires to make appeals regs in relation to that kind of decision, which we see in the 2020 regs, is precisely because of this section. And importantly then G, any other decision, again you see the word decision, there's no decision at a later stage.
Sorry, any other decision.
Yeah. Any other decision made in connection with restricting the right of a relevant person.
Yeah.
So I can make 2 points on the back of that, my lord, my ladies. First of all, the interplay between F and G shows clearly in my submission that Parliament, and so it's not just the Secretary of State thinking about the debate we had earlier with its Parliament. Parliament.
I think I can see where this is going.
Sorry?
I think I can see where this is
Yeah. Well, Parliament understood that a decision to make a deportation. First of all, if you think about the relationship between F and G,
Yeah.
Parliament understood that the decision to make a deportation order referred to in F is a species of decision in connection with restricting the right. So Parliament itself, bearing in mind it's specifically trying to implement the Withdrawal Agreement here, Parliament understood that a decision of that kind is a species of decision that restricts the right, which it knew because of Article 21, among other things, it had to make provision for appeal rights in relation to. And secondly, and in any event in light of G, forget about F for a minute, Parliament made a deliberate decision to locate the right of appeal that it knew it had to provide under the Withdrawal Agreement in respect of decisions restricting rights in regulations made under this section. which we'll see in a minute is the 2020 regs. Now, to come back to another debate that was had a moment ago, Mr. Hickman acknowledged it's quite a weak submission to say use the regulations to interpret the withdrawal agreement. I see that. It might be one stage better to say you use the statute to interpret the withdrawal agreement, but frankly that's problematic for similar sorts of reasons as well. But I don't think one has to put it that way, and again, to some extent, you've had this debate with Mr. All we have to say on this side of the room, as it were, is that Parliament was entitled, knowing it had to locate appeal rights, and bearing in mind Bouchereau and all the rest of it, Parliament was entitled to locate the right of appeal here, and not only after the deportation was made. In other words, one way of thinking about it is to say, I mean, and if you think about it this way, it becomes almost silly. Is it really to be contemplated that if this goes, if you do make the reference, or if a case finds its way to the CJU in due course, that they would solemnly say, no, 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 you've provided this right of appeal too early. It's incompatible with the withdrawal agreement. I mean, obviously not. It's going to say that's where the domestic scheme has chosen to locate the right of appeal. And that doesn't create any problems under the withdrawal agreement. So not because it's an aid to the construction of the withdrawal agreement, but because it's a legitimate implementation of the withdrawal agreement to do it this way. And it's perfectly clear that that's what Parliament has done.
If an offence is, if one is in Article 20.1,
Yeah.
so pre-implementation day,
Yeah.
would these and the regs be the avenue?
So I think,
for appeal?
off the top, but I've met some others. I think the position is no. It is or it isn't.
So, yes, they would be, madam, for a person in this position with an indefinite right to reside,
They would
where the
use-
decision is taken for the first time. At the times these decisions were taken. So if these decisions had been based on pre-IP conduct, this would have been the right of appeal.
So the same point about whether
Yeah.
the decision restricts the right to reside, in theory,
Well, not in,
would
yes,
arise then.
Yeah.
yes, the FTT should be dismissing them as without jurisdiction because
Yeah.
it's brought too
on the
early.
Secretary of State's analysis. I think that's right. I'm grateful.
Well, that may be quite an important.
Yes, it is, and that's not a point that your ladyship is a very acute point. In my opinion. I mean, I don't know what the Secretary of State would want to say about that. It does seem it seems problematic for her. The point having just arisen, perhaps we'll all.
So the same would apply to pre.
Yeah. So it may well be that the Secretary of State's managed to prove that her whole scheme for dealing with pre-IP completion day conduct doesn't work, which seems a bit problematic as well. But I mean, frankly, I don't think I need that point, but it does seem to rather assist as well.
Well, I'm just trying to understand.
No, but I mean, thank you for that. I'm sorry I didn't know the answer. I'm told I was in a case about it, but I mean, like my pupil supervisor, I forget about cases as soon as I finish them. Right, I'm not sure I don't know if it does quite answer that, but we'll have. Yeah. Anyway, but anyway, that point aside, I mean, I hope you see the point I'm making. I mean, Parliament has chosen to locate rights of appeal in relation to decisions restricting rights in this scheme, and in the 2020 regs. And unless that's not legitimate, it would be very odd to interpret the tribunal which hears those appeals as not having jurisdiction to deal with the issues which arise under them, in my submission.
So you say that's bullseye on ground one.
I say it's pretty bullseye on ground one, along with all the strong bullseye points that Mr. Hickman's already made. Last point on this. I said there's only one other option. So the other option is that the Secretary of State, in dealing with human rights, then entertains, this is stage 2, entertains a human rights claim, I think it's called. You need to go to section 82 of the 2002 Act for that. Authorities, page 53. So this is how the human rights aspect is dealt with. So if you've got page 53, page 82, and I should say, but I'm not going to go into that, but Section 82 has been very extensively amended from the form it had 20 years ago, but I don't think that matters. So Section 82.1, a person may appeal to the tribunal where A, or let's focus on B for now, but they're all similar. The sexual state has decided to refuse a human rights claim made by P. So that's the only other time you have a right of appeal. So you make your claim that it would breach your human rights to be deported. I won't go through all the definitions in the section for now.
No.
And then Section 84 tells you what the grounds of appeal are. And they are only that, see Section 84.1, A, breaches the Refugee Convention, that's if you've made a protection claim. B, breaches humanitarian protection, not relevant to us. Or C, breaches human rights, but not breaches the Withdrawal Agreement. So, as I understood it, certainly at one point, the Secretary of State's argument was you have to, even if we're wrong on ground 2, and there is a proportionality element in the Withdrawal Agreement, you have to raise it at stage 2, but there's no jurisdiction for the
Doesn't
court.
work.
Just isn't possible. So I think the Secretary of State has to say, well, actually, I think the Secretary of State is driven to saying that if we're right on ground 2, and of course I know that she says we're wrong on ground 2, but she's driven to saying if we're wrong, if we're right on ground 2, then her statutory scheme doesn't allow for any of this to be ventilated, and there's an incompatibility. None of us are arguing for an incompatibility. We say perfectly clear right. Whereas marry that up with, and I won't go back to it because Mr. Hickman's shown you, Regulation 8 of the 2020 regs, where the ground of appeal is a breach of Chapter 1 of Title 2 of the Withdrawal Agreement, it clearly encompasses this point if we're right on ground 2. So it's a very odd position for the Secretary of State to adopt, frankly. So that's ground 1. Ground 2. Was my lord going to ask me a question?
No, I joined the question. Okay. Round 2, yes?
Yeah, and I think I seem to be doing all right for time. So, again, align myself entirely with Mr. Hickman on this ground, not making inconsistent arguments. And I just want to emphasise one point in my oral submissions to you. But in terms of the way I thought about it this morning, it interacts with one of the discussions that was had with Mr. Hickman, I think, at the start of the afternoon, because my lord asked Mr. Hickman, why do you, Mr. Hickman, need
28, 27, 28. Why can't you stick with 30, 31?
Yeah, exactly. Now, I completely, again, I adopt what Mr. Hickman says about all of that and where the line will be drawn. I mean, subject to seeing his note telling, but I mean, I think we're likely to adopt what he says. But to provide you with if you like, a pared back, the argument that I'm going to emphasise to you is a kind of pared back version of the essentials of the argument. And I do say that my lord's question was an acute one, if that's the right way of putting it, perspicacious, not a word I can ever say, one. Because actually all that we do need is Article
31.3.
Yeah, because that expressly incorporates proportionality. Now, it may be, Mr. Hickman may be right that you get a bit more out of the others. I'm not going to talk about that.
Incorporates proportionality without even the cross-reference to Article 28? You've just
well, sorry, no, but then you get it via the cross-reference. Then you get
so
it.
So you need the cross-reference.
I don't actually accept that you do. I don't accept that you do.
If you don't need the cross-reference, where do you and how do you anchor proportionality?
For the reason that I was going to say anyway, that Mr. Hickman has just whispered to me, which is that Chinchilla doesn't have the cross-reference. So you'll recall, I won't go back to the authority. I know you've done some reading of it over lunchtime. But that's a case where someone is being removed essentially because they don't have a right of residence. There's no conduct.
But doesn't...
So I said I wouldn't go to the other authority. We've kind of got there, that's fine. I wasn't going to take you to anything, but I can see you want
We want to go to it. Yeah.
You want to go to it, that's fine, of course.
Okay.
I'll deal with the question.
let's have the.
I mean, perhaps if I make the point as I see it, and then if that's helpful. So, sorry, let me just turn on the passages again. So this is a case where the individual, as I understand the facts, the individual did have a right of residence, no longer has a right of residence under EU law.
Yeah.
So the member state doesn't have to rely upon. Is not restricted to relying upon grounds of public policy, security, etc. in the CRD, but where there's still, says the CJU, a freestanding requirement for a proportionality analysis, which comes in via Article, as on the facts of that case, Article 15, but equally a fortiori Article 31 as well would do it. In other words, what it shows, for the purpose of the question my lady asked me, is that you can, and the CJU has imposed a proportionality requirement, even in a case which is untethered from any specific EU grounds.
But does that case give us any guidance as to how you apply that proportionality?
I'm not sure that it does.
Yeah.
But that's a separate question. I mean, the baseline question in this appeal is, I mean, I think you would then go back to the other, and I really don't want to trespass on this in my short time, but you would then go back to the Lumsden and so forth on what proportionality involves, and you'd have to apply those principles to that. I mean, I want to be clear. I'm not saying that Mr. Hickman is wrong in his blue pencil analysis. I'm just giving you the most, I positively say he's correct. I'm giving you the most pared back version of the argument, because the argument is there is a proportionality, there's a requirement for proportionality exercise,
yes,
which is essentially the same as an individualised.
Although paragraph 85 of Chisinchula says, as it does, the last word, also ensure that the decision in question is not disproportionate.
Yeah.
In Article 31.3, that's followed by the phrase, particularly in view of the requirements laid down in Article 28.
Well, but my lord, two things about that. It says particularly.
Yes.
It doesn't say only. Or
Yes.
for these purposes. You see the point. So in other words, yes, it's true. I mean, a lot of these, bear in mind the way that was drafted, a lot of these cases would have been under, that the CRD was concerned with would have been public policy, etc. cases. But it does only say particularly in light of. I don't have it in front of me right this second.
It does say, particularly in view of the requirements.
Yeah, so it's not, it's an including, if you like, not a, it's inclusive of that, it's not definitional, it's not restricting it to that. In all cases, you've got to do proportionality, particularly in light of. And again, I want to be clear. I mean, I also say you do incorporate Article 28 via Article 30, the right way around, 31.3. But that's, can I just develop the argument I was going to make? Because,
sorry, yes.
Because the dividing line, you see, the point is that, the point I think, if I've understood correctly, that might have been troubling the court a little bit, I can see why without, is, well, do we really have to say when would we really have to go through line by line every provision of chapter 6 and say this bit is grounds, this bit is safeguard, this bit is grounds, this bit is etc. And certainly do we have to do that today, as it were? And I can see you might be reluctant about that, and there's scope for a bit of argument about which side of the line certain of them are on, perhaps. And I don't want to revisit that. But what I want to do is to say, this is the argument I'm going to come to in just a moment, is to say that on any view, Article 31.3, on any view 31.3 is incorporated, on any possible reason, on any view, because it says so in terms, 31.3 brings in proportionality, because it says so in terms, and that's enough. But just to make that point, if we just turn back up Article 21 again for a moment, page 150 still. Page 150. It is actually in my respective submission.
Sorry, Article 21 of
Oh, sorry, of the withdrawal agreement.
Yes.
Yeah, no, I need to tell you that. So page 150, so the critical provision, really.
Yeah. Yes.
And, you know, in a sense, the point is a very simple one, because and I think it's Miss Smythe who emphasises this, even leaving aside the point that Mr. Hickman makes about bringing in EU law principles and so forth, the basic rule of the Vienna Convention, as I understand, is you follow the ordinary meaning of the words. Well, just follow through the ordinary meaning of the words. Article 21, safeguards, that's important, and rights of appeal. So safeguards can't be the same as rights of appeal. The safeguards set out in Article 15 in Chapter 6 shall apply in respect, and then you've got the words I emphasise for a different purpose, any decision restrict residence rights. But it's what is it that shall apply? It's the safeguards. And where are those safeguards found? Well, they're found in Article 15 and in Chapter 6 of the CRD. Now, allowing, as I'm inclined to, that there might be room for argument, at least, about whether, let's say, I forget which one it was, but is it the first sentence of the second indent of Article 28.2 is or is not a ground or a safeguard? I'm not saying it is or it isn't, but there might be a difficulty about it. What does safeguards in Article 21 encompass when it's referring to the CRD? Well, on the most orthodox and basic approach to interpretation, the word safeguards in Article 21 must marry up with the word safeguards in those bits of the CRD. And where do we find, and I won't go back to it because you've seen it lots of times, but where do we find the word safeguards in those bits of the CRD? You find them in the heading to Article 15, and you find them in the heading to Article 31.
You do.
So the simple question is, do you whatever else may be a safeguard as opposed to a ground,
It has to be 15.
it's got to be 15 and it's got to be 31.
Yes. Well,
And that's the most simple.
That was sort of behind my question to Mr. Hickman.
Well, I
at the start of the
anticipated it
afternoon.
might be, but that's. I mean, really, I know that's very simple, but nothing wrong with that. I mean, it really is. It can be as simple as that. Now, all of that you then get into, and you know, insofar as there's any doubt about it, you then get into Chen Schuler, and on whether, and it makes the important point that. I mean, other than the point we looked at a moment ago, the point that Mr. Hickman made earlier, which is that the CJU treats proportionality as an aspect of a procedural safeguard.
Yes.
That further reinforces everything we're saying. But just on the basic wording of the relevant provisions, which are Article 21
Yes.
and Article of the WA and Article 31 of the CRD, you're there. And for all I didn't want to repeat everything Mr. Hickman said, but respectfully, he's right. There's no reference in any of this, in either the CRD or the WA, to substance or substantive or something of that nature. And it's quite instructive, in my submission, that although the word procedural appears in the CRD, it doesn't appear in the WA. So in the WA, it's all it's safeguards, not qualified, safeguards of any kind. Now, it may be that implicitly that's meant to mean what the EU legislature would tend to call procedural safeguards. Maybe that's right. I don't have a problem with that. But certainly you can't use anything in the WA to cut down on what are described in the CRD as safeguards, because if it were the other way around, if the WA said procedural safeguards and the CRD said only safeguards, you might say, well, okay, here's the safeguards, we have to decide whether it's procedural or substantive, but it doesn't work that way. It's the other way around. So anything that is a procedural safeguard in the CRD must be one of the safeguards that's being contemplated by the WA.
Yes.
And, you know, last point then, and I think I'm within my time, if you then come back to what is there that tells against that? Well, Mr. Hickman's absolutely right. The Secretary of State's argument depends on a distinction between substance and procedure, which doesn't feature in the EU case law and doesn't feature in any of the I'll use this word loosely, legislation. I know the WA is not exactly legislation, but you know what I mean. And so that distinction just doesn't feature. The distinction which features is grounds as opposed to safeguards, not procedure versus substance. And otherwise, there's nothing else in Article. The only thing you would have to have some very strong imperative in Article 20, in my submission, to make you cut down on the clear language that I've pointed to in Article 21. And do you? Well, I would submit. Not surprisingly, no. All that Article 20 sub 2 does is tell you about the grounds. And that word doesn't begin to give a sufficient imperative to cut down on the, with great respect, blindingly obvious inference that when they talk about safeguards in one bit of legislation, they're talking about the safeguards in another bit of legislation. So, and that's before you get, and a lot of those submissions I can make without reliance on general principle EU law, without reliance on gentula, but for all of the reasons given by Mr. Hickman, they're only greatly reinforced by them.
Thank you.
My lord, my ladies, those are my submissions.
Thank you very much, Mr. Booney. Now, Mr. Rogers, you next?
I am, but I believe
Oh, no, Miss Smythe.
Can I just mention something? The problem that my Lady Justice Falk raised about the appeals regulations doesn't in fact arise because there are various different routes to appeal rights. And in the class of case that your ladyship mentioned, that particular provision, these particular regulations won't be applied. We can certainly do a note for the court on that, but it's
Well, we'll look forward to hearing you on that tomorrow, Miss Smythe.
Yes.
Thank you.
Just on that, can I say, I mean, the question arose in the course of argument. It's not central to what I'm saying in any event.
Thank you. Yes, Mr. Rogers.
Ladies, my lord, the IMA supports the appeals insofar as they concern the interpretation and application of the withdrawal agreement. The IMA takes no position at all on the ultimate disposal on the individual facts of either case, and this reflects its role as set out in the skeleton, which is to monitor and promote Part 2 of the withdrawal agreement rights. The IMA is intervening in both appeals. You
have a right to intervene, do you?
Well, we have the right to apply to intervene.
Right to apply, is it?
Sorry, I don't. One of the there's a statutory provision which sets out the IMA can apply to intervene.
Apply, okay, right.
Essentially, in this case, its concern is only with certain points concerning the interpretation of the withdrawal agreement.
Yes.
That's why we make no submission on one of the grounds which has occupied your time today, and we're looking at the safeguards and grounds principles. Also, obviously, I'm the first to speak on the Molnar case, but in fact, all I need to say is that in Molnar, the tribunal followed Vargova, and obviously, I'm not going to open the case on that, which is for Mr. Cox later. As to my submissions today, I'll begin with an overview of key issues affecting the interpretation of the withdrawal agreement in these appeals and the nature of the problem to be addressed by way of a 10-point summary. Then I'll turn to the framework of the CRD. It's always helpful to find 10 points, I find. I'll turn to the framework of the CRD, secondly, concerning the removal or deportation of EU citizens and family members.
Sorry, I was reflecting.
So the second.
Distracted me by the reference to 10 points. I'm about to respond.
That isn't part of the 10 points.
Some advocates think you should always have an odd number of points.
Yes.
Some people say so.
So I hear.
As part of my submission on the framework of the CRD, I think that it is important to try to track and separate the grounds and the safeguards distinctly before and after the change in law.
Okay, so you're going to have another go.
It's already set out in the skeleton, which I should say was carefully crafted by Robert Palmer, Casey, and I had to sign my name on it when I came in at the replacement skeleton stage. But there is already a quite an exhaustive attempt to do that.
Yes.
There are some differences from the way Mr. Hickman put it. So
Okay,
I'll
all
just
right, we'll
mention
come on to
some
that
points.
when you've got through your 10 points.
Yep. And but we focus first on what existed before, so that we can understand what happens after the change in law.
Okay.
So then we'll turn to the withdrawal agreement provisions, Article 20 and 21, to give our interpretation of that. Fourthly, then look at the domestic law provisions implementing the withdrawal agreement and how they affect other domestic law provisions, the UK Borders Act. Fifthly, just talk briefly, if there is time, about aspects of the judgment in Vargova, but you've already heard quite a lot on that, so it may be that I simply refer to the skeleton. And then finally, on the question of relief, the IMA's position is that there is no need for a reference. It's clear. So beginning with the 10-point overview, firstly, Article 21 of the Withdrawal Agreement, which is headed Safeguards, plural, and Right of Appeal, states that the safeguards set out in Article 15 and Chapter 6 of the CRD shall apply in respect of any decision by the host state that restricts resident rights of those within the personal scope of Article 10. In this case, on the facts of this case, it is Chapter 6, we say, that provides the relevant safeguards in answer to one of the points earlier. Article 15 is important for interpretive value.
Yeah.
Secondly, Article 15 and Chapter 6 of the CRD are union law provisions, which is the phrase from Article 4 of the Withdrawal Agreement.
Yes.
Article 21 of the Withdrawal Agreement is a provision of the Withdrawal Agreement referring to union law. And so all of the consequences of Article 4 apply. And you've already heard a lot about the principle of equivalent effect. We must produce the same legal effects in the EU and UK. Point 3, under the former EU law regime, which is the law applicable up to the end of the transitional period, Article 20.1 of the Withdrawal Agreement, the EU law proportionality principle, must be applied by both the decision maker, and that's Article 27.2 of the CRD, and on appeal at Article 31.3. We say the scope of the appellate body's task, as a result of Article 31.3, as a safeguard, is to include a verification that the decision is not proportionate. Now, the tribunal in Vargova, well, verification may be the word you're checking. I don't mean any more than...
It's not disproportionate.
A verification that the decision is not disproportionate.
Yes.
I said proportionate. I realise now why you watch it, but...
Yes.
So, that task, which is the appellate body's task, can actually sensibly be described as a procedural safeguard.
Yes.
If one decided that a procedural substantive distinction was important, which we say it isn't. But in fact, Article 131.3, in requiring that the appellate body's task should include a proportionality assessment, is itself sensibly described as a procedural safeguard. So,
But it's called that in Article 31.
and it's yes. Well, you say it. You
That's
suggest
what
as
it
if
is,
it's a very
procedural.
simple point, but it's the one that the Vargova decision effectively gets wrong, because they say that's that Article 31.3 is not a procedural component; it's a substantive provision, and therefore must be stripped out of the law. So it does seem obvious because of the heading, but we have to make that point good. But it can sensibly be described as a procedural safeguard, not only because it falls under that heading. But that's only if one thinks at all that there is any sense in the procedural versus substantive distinction which the upper tribunal in Vargova sought to draw. We say the search for a distinction based on what is procedural versus what is substantive is illusory. That appears to be the case of the Secretary of State as well. It's not a distinction which we can find in the CRD. It's not a distinction which is found in the relevant withdrawal agreement provisions. and applying Article 4 of the Withdrawal Agreement and AT, what we should really be doing is working out how the Court of Justice of the European Union would answer this question and interpret these provisions of Union law in Chapter 6 of the CRD, made applicable through the Withdrawal Agreement, and looking to ensure that the same legal effects are produced in the UK as in the EU. And it's inconceivable in our submission that the CJEU would exclude the EU law principle of proportionality on the grounds that it is somehow a substantive protection which does not get carried across into the Withdrawal Agreement. There's simply no basis for the procedural versus substantive distinction. That was my fourth point. The fifth point, if the relevant conduct on which the deportation decision is based occurred before the end of the transitional period, Article 20 is straightforward. For both the grounds, which is public policy, security, health, and the safeguards, you apply Chapter 6 CRD. Sixth point, in these appeals, of course, the relevant conduct we're concerned with occurred after the end of the transitional period, and it's here that the Withdrawal Agreement permits divergence between the UK and EU. And that divergence is limited to defining the conduct-based grounds which the host state may decide constitutes grounds for restricting the residents' rights. That's because Article 22, I say may, I emphasise may because it is permissive or discretionary. Previously, of course, the conduct was defined UK and EU-wide by the CRD, public policy, public security. But after the end of the transitional period, the definition of the conduct which may form the grounds for deportation is transferred effectively to the competence of the host state, who are to provide for these grounds in accordance with national legislation. Seventh, in the Article 20.2 case of post-transitional period conduct, whilst we look to Article 20.2 for the grounds, and the grounds only, as these decisions in these appeals are, for the reasons given, a decision restricting residents' rights, that's any decision in Article 21 is triggered by that. For the safeguards, plural, and right of appeal, we must apply Article 21.
Yeah.
And it is Article 21 which includes the EU law proportionality principle, we say. Article 21 includes the EU law proportionality principle both at the decision-making stage, and that's based on Article 27.2 and Article 28.1. So the decision maker must apply a proportionality assessment, and also it's at the appellate stage or review stage, 31.3, where it's said to be an essential component of the appeal or review. So that is how these provisions should have been applied in the tribunals below. But point 8, the tribunals fell into error in these cases. We do not need to distinguish between them because the principal error in Molnar was to follow Vargova. And point 9, the 4 principal errors regarding the interpretation of the Withdrawal Agreement, which we're concerned with, and on which this intervention is focused, these were set out at paragraphs 3.1 to 3.4 of our skeleton, but broadly speaking, consisted of the following 4 errors. Firstly, failing to distinguish between the provision made as to grounds and safeguards between Article 20 and 21, that's the grounds versus safeguard error. Secondly, wrongly restricting the safeguards applicable pursuant to Article 21 of the Withdrawal Agreement to the Tribunal's own conception of what are procedural safeguards, which could not exclude any assessment of proportionality in its view, because it found that proportionality ceased to be applicable after the changes in law, and because it was a substantive principle. Thirdly, the tribunal in Vargova wrongly concluded that sections 32 and 33 of the UK Borders Act were compatible with the Withdrawal Agreement insofar as they applied the automatic deportation regime for foreign criminals in respect of EU citizens falling within the scope of Part 2, where the conduct giving rise to the criminal conviction occurred after the end of the transition period. And fourthly, finally, in terms of errors, the tribunal misunderstood the force that the Withdrawal Agreement has in domestic law. So in a number of places, we submit that it has misunderstood Section 7A and 7C of the 2018 Act, including the power and the duty to disapply inconsistent legislation. So then the 10th point is that the IMA considers the error of the tribunals is clear. The UK is presently in breach of its obligations under the Withdrawal Agreement, and to bring that breach to an end, this court should allow the appeals, and there's no need for a reference.
And what, if anything, do we do about the incompatibility?
So the incompatibility, I could take your lordship to that point ahead of time if you wish.
Well, no, don't do that. At some point.
At some point, yes.
I'd like to know for my part, I'd like to know what you say we should do about the incompatibility.
Yes.
Come back to it.
Yes, it's a point to do with exception 7 of the. There is a solution there, we would say. I'll come back to that and make sure we cover it in the time available. So turning then to the knotty question of the framework in the CRD and tracking the distinction between grounds and safeguards that we also say is important.
Yes.
Firstly, I accept that there is a tension in the task that this court is undertaking, because on the one hand, the IMA would wish to press this court to give as much guidance as possible for future cases, so that there is certainty in the law as to how the proportionality test comes to be applied. So, although it is a shortcut in this case to simply stop and find that Article 31.3 clearly includes a proportionality assessment, and that is sufficient to dispose of the appeals, it is more helpful for giving guidance to other tribunals to also deal with the Article 27 and 28 points.
But anything we said that wasn't essential to deciding this case would be obiter, so it wouldn't bind anybody.
Yes, I think it wouldn't be obiter in this case because although one could say, well, the tribunal made an error, in fact, it was also
the decision
maker made an error as well.
Yes. Your point is that 31 applies to appeals.
Yes.
To redress, whereas 27, 28 applies to decision making.
Yes.
So you say it does arise in this case.
Yes, and it's an answer to the question which your lordship mentioned about do we need to do any more than 31.
Yeah.
But generally, in terms of do we need to track through the CRD in what your lordship described, I think quite rightly, as the tortuous task of working out what's the ground and what's the safeguard, it may not be necessary for this court to answer the question in relation to each of those provisions, because at some point it may be that good law is made by letting a few cases come before the tribunals below. But there may be some assistance in us at least going through it together. But as to how far this court needs to go in its judgment, there is obviously a tension in that we are looking for as much guidance as possible, but sometimes it's better to let to decide what's necessary to be decided on the facts of this case. And this is clearly
one of this court is
yes.
to decide what you don't have to.
Exactly.
Indeed.
Because you can't anticipate what's going to come up in another case.
Indeed. But in any event, even if one adopts that approach, there's the interpretive value of going through the
Yeah, I mean, being serious, it may well be that we can find ourselves to when we come to consider our decision, but there's certainly no harm in a more expansive,
yes.
moderately more expansive
yes.
investigation.
Yes. So one can see some guidance from the approach that the Grand Chamber in Centulia took, where it obviously went through the provisions to some extent and decided which didn't apply, because that was an Article 15 case and they were dealing with whether the conditions of that right no longer existed, and therefore provisions relating to public policy, public security didn't apply, and therefore they could make clear to some extent those provisions didn't apply. The task of this court is perhaps a little more difficult, because the CRD has obviously been drafted in a way where grounds and safeguards didn't need to be precisely separated at all. And so when Ms Smythe will tell you that they're all intertwined, she's right to some extent, because you will find grounds and safeguards sometimes in the same provision. And it didn't matter under the CRD to separate them in a very clear way, but sometimes now it will, because we have to apply the safeguards set out as a result of the withdrawal.
But not the grounds.
No, so for the grounds, we only look to Article 20.2, and we say that's within the competence of the host member state to define, but it's a very clear line. It doesn't leave the member state with any more to do than that. It can't.
No.
And so then, if you're with me on that point, and that 22 is entirely restricted to the member states having the power and the competence to decide what the grounds are, conduct, then when one tracks through the CRD, you may say that provisions of the CRD which are inconsistent with the member state having the competence to decide what conduct should constitute grounds, then you don't apply those provisions of the CRD. And here there is a slight difference, not an important difference. I think Mr Hickman, his first position before his alternative one, in relation to previous criminal convictions, was that would apply in relation to Article 22, but we would say that the part of Article 27 CRD stating that previous criminal convictions
In themselves.
Yes, that can't sensibly be carried over and be consistent with Article 20.2, because Article 20.2 in our submission does allow the host member state to decide that previous criminal convictions could be defined as conduct constituting grounds for restricting the right of residence. What matters for the purpose of this appeal is not really that point. What matters is that is only the Article 20.2 grounds stage. One then has to apply the safeguards. So if one is to decide that, as in the UK's case, previous criminal convictions can constitute grounds for restricting the rights of residents, then the UK can do that within Article 20.2.
Now,
But it's
I may have
forgive me,
I may have misnoted this, but I thought Mr Hickman was saying that the second sentence of 27.2, the previous criminal convictions are not in themselves sentence, was a safeguard and not a ground.
Yeah, so I think I noted that he said the first sentence was a safeguard. The second one may be a ground, but
I've got safeguards arrow next to 20, next to the previous criminal conviction.
I think his primary submission was that it was a safeguard.
Yeah.
Very well.
I think you are differing from him on that.
Yeah, so we are differing. So the point is that I think
You say it's grounds.
I'd say that's a grounds. It's a definition of grounds.
Well, grounds appears in the sentence.
Yes, and that is an example of how one has to take care in deciding what gets carried over as a safeguard, because that is difficult to square with Article 22 because of the competence of the member states. But for the purposes of the appeals, it doesn't matter, because what matters for the purpose of the appeals and the interpretation of this is that that the decision maker and the appellate court are applying all of the safeguards, which include proportionality. Mr Hickman would say, well, that might be a safeguard. I don't think it sensibly is. But what matters for these appeals is that proportionality itself does get applied.
Well, on one view, contrary to what Mr Hickman said, I'm not expressing a view, I'm just testing the whole
Yes.
argument. 27.2 as a whole is about what you're calling grounds, and perhaps Ms. Smythe is going to call substance. Let's not get bogged down in language. Because it's the second part of the first sentence of 27.2 is about the conduct. That's about the grounds, isn't it, on your analysis? So isn't that one interpretation? The reference to proportionality there is about the substance stroke grounds of the decision, not the procedure.
With respect, no, I would say that the first sentence of 27.2 has to be a safeguard, as indeed Mr. Hickman said, because it's saying that measures which are taken on grounds of public policy or public security, okay, so we're in a grounds case, that's been established. They shall comply with the principle of proportionality. That's just saying they are to be subject to the safeguard of proportionality.
And shall be based exclusively on, what's that?
Yes, so shall be based exclusively on the personal conduct of the individual concerned. That sounds like a definition of grounds.
Yes.
But the principle of proportionality can only sensibly be considered a safeguard. So that's entirely consistent with the way that we analyse 20 and 21, because grounds are the conduct on which your decision to restrict right of residence is based, and safeguards are the controls put upon the decision maker or the appellate court. So yes, it is difficult because one is faced with dividing not only sentences of the same provision, but also clauses. So the first sentence I would accept. The first sentence begins as it's a safeguard, but the last part of the first sentence is about the ground.
Segues into a ground.
Yes. There's nothing wrong with that in my submission. And it's just a consequence of the fact that the draftsman didn't need to separate.
In the hurly-burly.
Yes.
Well, this isn't the hurly-burly, this is the deliberative process.
The lady's right,
that
I was being
leads to legislation. So there's no hurly-burly about any of this.
We also stand corrected.
She's right.
Sometimes.
So the mere fact that the last phrase, or the phrase, comply with the principle of proportionality, appears in the same sentence as a mixture of definition of grounds doesn't mean that it's not a safeguard in our submission. And that's because it just wasn't necessary to split them out.
But just going back, to what extent do you need 27, the reference to proportionality in 27.2, if 28.1 sets out essentially what proportionality means?
I think it's more coherent to consider 27.2 together with 28.1.
Well, because 27 is general principles?
Well, because 28.1 begins by saying, before taking an expulsion decision on grounds of public policy or public security. In my submission, they were meant to be read together, but
An expulsion decision might be a subset of measures taken on the grounds of general public policy and public security.
yes. But I do also say that it's quite clear from the language of Article 28.1 that which is clearly a safeguard, and I noted Mr. Hickman said the same.
28.1 is a safeguard.
That's clearly a safeguard. It's a direction to the host member state as to what should typically be taken into account. And it sounds very much like an examination of the facts and matters, which are then to be weighed in a proportionality assessment. It's looking at things which I think are quite context specific. So although I'm not very enthusiastic about Mr. Hickman's CRD proportionality, I think this is the EU law principle of proportionality that we're dealing with, but applied in the CRD. I can see that effectively what happens here is that Article 28.1 is saying that typically when you apply proportionality in the CRD context, and the grounds are public policy or public security, you are looking at the length of time that somebody's had for residence, the degree of cultural and social integration, and so on.
Can I go back to Lady Justice Falk's point? Well, on your case, I think the only safeguard in 27 is the first part of 27.2. Given that this is an article dealing with general principles, isn't it neater, and I'm not agreeing with your case, I'm just refining your case, isn't it neater to focus on 28, which after all tells us what proportionality means, doesn't it?
Well, I suppose without the reference to proportionality in the general principles,
yeah,
you might say 28 is kind of floating free, whereas if you have to take into account the principle of proportionality, what it's telling you is what you weigh in favour of the foreign criminal in one, and then it's telling you what weight you give. I don't know.
I understand the difference. I suppose the way the case was presented, indeed by Robert Palmer Casey originally, was that Article 27.2 and 28.1 are to be read together, and together it's quite clear that they're talking about proportionality and the factors to be considered typically. If this court is of the view that 28.1 independently can be found to be a proportionality safeguard, which is to be applied by the decision maker, then I suppose 27.2 doesn't add very much, because 27.2 is simply saying shall comply with the principle of proportionality.
But is there anything? Sorry.
Yeah, 28.1, of course, 28 is specific to expulsion,
It is.
whereas
Yes.
the chapter is broader. So, I mean, in this particular case, you might say, because we're dealing, presumably you'd say an expulsion decision is a decision to make a deportation order is an expulsion decision, I take it, within 28.1, or that's what you would say.
Yes.
And so on the particular facts of this case, where you're dealing with deportation, you might say 28.1 tells you all you need to know about proportionality. I don't know. Question.
Yes, I think that could be right. I think that probably is right. It's 28.1 alone. Once that's characterised correctly as a proportionality assessment, or at least a direction towards that task for the decision maker, then it's difficult to see what other parts need to be brought into that. So I think I'm happy to accept that submission.
Right. Do you want to say anything more about the CRD?
So, moving on to Article 30, those
Okay.
notification rights are clearly safeguards, and Article 31 obviously is headed procedural safeguards, and I think the point's been made many times today that obviously it's within that heading that we find 31.3, which is a provision defining the scope of the redress procedures and includes the requirement that the decision is not disproportionate, and therefore that's a procedural safeguard. I think that's sufficient to track through the grounds and safeguards. Obviously, there's more to be said, and you'll find it in the skeleton argument.
Yes.
That's sufficient. Article 15, I think, is not so important for these purposes, but again, it's been dealt with in the skeleton argument. I'll move on to relevant withdrawal agreement provisions. That's also been dealt with already twice. Article 4, of course, is key to this case. That's at page 139 if one wished to turn to it. But we say Article 4.1 is the core principle, the requirement that the provisions of this agreement and provisions of union law made applicable by the agreement shall produce in the UK the same legal effects as
Yeah.
those produced within the Union and Member States. You then have the direct effect provision in the second limb of Article 4.1 and Article 4.2 is the judicial mechanism to achieve the central goal, which is in Article 4.1. That's the power and the duty to disapply inconsistent domestic provisions. And then Article 4.3, of course, is the interpretive method, which is so important to this case. We submit that these provisions combine in effect to require that all judicial bodies, including the tribunals below, should disapply domestic provisions which are incompatible with the provisions of the Withdrawal Agreement and also with the provisions of Union law made applicable by this agreement. Article 4.1. Courts, of course, reminded Article 4.3 refers to the concepts or provisions of Union law, and these are to be interpreted and applied in accordance with the methods and general principles of Union law. And we say the general principles of Union law include proportionality. The net effect of all strands of Article 4 are to produce, in respect of and in the UK, the same legal effects as those within the Union and its member states. I'll turn then to the domestic law provisions that your Lordship mentioned, which implement the Withdrawal Agreement and how they affect the domestic law provisions relating to deportation of foreign criminals, and look at the UK Borders Act point, which I know your Lordship wanted me to cover in the time available. And to the extent, of course, I haven't covered everything in the skeleton, we maintain the position. The implementation of the Withdrawal Agreement in domestic law. This is for reference at paragraphs 35 to 39 of the skeleton. I won't take you to that. But the domestic law on deportation has already been covered by Mr. Hickman. The problem, it seems to me, is exception 7, which is taken to. And exception 7, of course, provides that where a foreign citizen is a relevant EU citizen, and it's based on conduct which took place before the end of the transition period, and there's no exception to provide for what happens to conduct occurring after the end of the transition period. The reason exception 7 is there is because the proportionality assessment required by Article 20.1 of the Withdrawal Agreement, that's pre-TP conduct, would be inconsistent with a mandatory duty to automatically deport a foreign criminal. But because Article 20.2, if you're with us in our submissions, concerns grounds only, then decisions relating to conduct occurring after the end of the transitional period must still, by Article 21 of the Withdrawal Agreement, be proportionate to the restriction of the EU citizens' preserved rights of residence. And so Section 32, subsection 4 of the UK Borders Act, which is at page 78 of the authorities, is incompatible with the Withdrawal Agreement.
Sorry.
So that's page 78. If you remember, 32.4 and 32.5, I think, are combined as shown.
So which provision is inconsistent?
32.4 in our submission.
4 or 32.5?
32.4 and 32.5.
And 5 are
What, without an expanded exception, basically?
Yes, which is from section 33. The way to bring the law into compliance and to put the UK not in breach, there might be different solutions. The solution which was set out in our skeleton effectively focuses on section 33 6b little b, and that's the provision providing for exception 7 to apply only in a case where the relevant conduct took place before the end of the transition period. Now, to try to consider what to disapply or how to bring this provision into compliance with the withdrawal agreement, it could be that the solution would be to disapply section 33 6b little b, because then the exception 7 would simply read where the foreign criminal is a relevant person. So you don't have to go to the trouble of adding in words or anything like that. You just delete little b, which provides for the temporal distinction. So the effect, if we're right on that, would be to allow for a proportionality assessment to then take place before any decision was taken to either deem a person's deportation to be conducive to the public good under section 35A of the 71 Act, Immigration Act, or to make a deportation order in respect of the foreign criminal concerned under section 5.1 of the 1971 Act. But in either case, that would ensure that any such action would not infringe the UK's obligations under 20 or 21 withdrawal agreement. The Secretary of State, of course, disagrees, and I'm sure Ms. Smythe will have plenty to say on that. She believes that section 32 and 33 and exception 7 are compatible with Article 22. But in my submission, that case rests on the false argument, as I read the skeleton, that deportations on grounds of post-transitional period conduct are determined entirely in accordance with national law. So that rests on Article 20.2 of the withdrawal agreement being given a weight which it can't bear. That requires you to read 22.2 as saying that in cases of conduct after the transitional period, everything is decided by national law.
Whilst your disapplication is neat, I think it ends up potentially drawing no distinction between Article 21 sub 1 and 20 sub 2 cases. So it's actually possibly more radical than your...
May go further than...
Yeah.
Yes.
I got the impression you had an alternative.
No, I'm afraid not. That was whilst there were other solutions that I was considering, I think sort of taking over this case, obviously I can only put forward the one in the skeleton, but that seemed to me to be the neatest.
But all it would mean is that the Secretary of State is not under an obligation, has no duty to make an automatic deportation order, but the Secretary of State will still have power to make a deportation order on conducive grounds, and in deciding whether or not to do that, the Secretary of State would have to take into account all the stuff that we've been talking about, if your argument is right.
Yes.
So it wouldn't prevent the Secretary of State from having different grounds in domestic legislation from the grounds that are permitted under the EU.
It wouldn't bring in all of the CRD rights for that class of people.
Yes, I see. Indeed. Yes, I mean, I'll rest the case on the submission as set out in the skeleton.
Thank you.
It may be that it's the subject to be the subject of further submissions after the judgment, depending on where the judgment ends up. Then finally, obviously, I've just about hit the end of my time. I wasn't proposing to take the court through the Vargova decision. We flagged up in the skeleton argument that there are certain key mistakes that have been made. One theme which permeates the decision is failure to understand the distinction between grounds and safeguards. The second major theme is the exclusion of proportionality from Article 21 of the Withdrawal Agreement on the basis of an artificial and unwarranted search for what is substantive versus what's procedural. Thirdly, the failure to find that Section 32 or 33 of the UK Borders Act is incompatible with the Withdrawal Agreement. And fourthly, some general misunderstandings apparent through the judgment in Vargova, which suggests that Section 7A and 7C, including the requirement to disapply primary legislation, 7A and 7C of the 2018 Act was not understood. So effectively, we say they started in the wrong place. They started from the proposition that the changes in EU law meant that proportionality which they characterise as a substantive legal principle, ceased to be applicable, and they worked from that to strip it out of what safeguards were to be applied. And for all of the reasons that we've suggested, that was the wrong way to approach it. And actually, at its heart, the case is quite a simple one, certainly in relation to Article 31, which clearly requires that an appeal should involve an assessment of proportionality. And it is correctly regarded under the heading which one finds it in, which is a procedural safeguard. So unless I can assist further, conscious of the time.
No, well, thank you very much. Now,
Yeah, sure.
I think we'll start you, Mr. Cox, now,
Good.
if that's all right. And
Maybe started.
because I'm a bit concerned that we might. I know Miss Smythe said she might want 4 hours, and then I think that's what she said.
That I said to Mr. Hickman was my minimum.
Yeah.
Particularly given the various matters that have been raised today, I need as much time as I can have.
Yes, well, that's why we're going to give you. We're going to make Mr. Cox start
very
now.
grateful,
Miss
my
Smythe.
lord.
But I hope that without unduly making you burn the midnight oil, you'll have a chance to reflect on all that we've heard this afternoon.
Indeed, my lord, and of course I'll be as crisp and as short as I can.
So far, we haven't covered as much in the oral hearing as was covered on paper, but we've still got Mr. Cox to go.
We have.
Mr. Cox, his arguments took us through quite an interesting historical trot through the background to some of these matters. I don't imagine you're going to want to go over all that.
I'm not. My lords, my lady, I'm going to try to avoid duplication, those who've gone before me, and to simply supplement the submissions that have been made, hopefully in a useful way. I really want to just cover 6 heads. Underground 1, firstly, that the withdrawal agreement allows for the UK decision to deport to be the occasion of the exercise of the rights under Article 21 of the withdrawal agreement. Secondly, I'll adopt the submissions that have been already made as to why the statutory scheme gives effect to that, but I want to take your lordships and your ladyships to an additional statutory provision that hasn't been mentioned so far. Thirdly, I want to supplement the submissions on why proportionality is required. Fourthly, what proportionality means.
Yeah.
Fifthly, the decisions in this case, and lastly, sixthly, disposal of Mr. Molnar's appeal.
Yes.
Firstly, in relation to ground 1, whether or not a decision to make a deportation order gives rise to the remedies under Article 21. And if I could just ask the bench to look back at Article 20 and Article 21 at page 150 of the authorities bundle. And really, I'm trying to build on what's gone before here.
Yes.
I'm not disagreeing, and I have the benefit, obviously, of having been able to listen to both sides and try and synthesise some points. So, Article 20, paragraph 1 and 2 refer to the conduct of union citizens or UK nationals, and that's a point I'll be drawing on in relation to the question of proportionality. And I do say that it means that it is the personal conduct of the individual concerned that must give rise to the grounds for the restriction. But turning back to the immediate question, Article 21 and 2 don't on their own say when the remedy should arise. They confer on or recognise that the state has a power, looking specifically at Article 20, paragraph 2, to restrict the right of residence. But what Article 21 speaks of, as Mr. Beauty's already pointed out, is a decision by the host state that restricts rights of residence. And in my submission, the character of decision must be interpreted to make that amenable to the remedies under Article 21. So the question, therefore, and it may be an obvious point to make, is that is not whether a decision to deport executes a restriction, but whether it is a decision, and I'm interpolating a word here, to make a restriction.
Yeah.
It's not contended by the Secretary of State that only a decision that is immediately executable attracts the remedies under Article 21. Now, what then are the withdrawal agreement constraints on what kinds of decisions can be decisions under Article 21? Well, I say, first of all, they must have been reached by a withdrawal agreement compliant process, so not too early, as it were. And secondly, they must be given at a time when the remedy is capable of being effective, so not too late. Has to be a Goldilocks decision, somewhere in the middle between those two. But where in the middle between those two is a matter for the national legislature. And the national legislature is entitled to identify the decision in its own domestic scheme that makes the restriction under Article 20 to which Article 21 rights adhere. And in my submission, there is nothing wrong in principle with that decision being a decision to make a deportation order and not the deportation order itself, which in distinction to Mr. Bewley's submission I would accept has the quality of a decision. But I dispute that the withdrawal agreement requires, or rather precludes, a state from giving a remedy under Article 21 before the executable decision of the deportation order. It is entitled to make the appealable decision earlier. That was always the case under EU law. As you'll have seen from our skeleton argument, the occasion for these remedies under European Union law was what was in substance a decision to make a deportation order. Exactly the same point that it is now. Yet if my learned friend's submissions are right, one would presume that all along that decision didn't meet Bouchereau, wasn't actually the right occasion for the exercise of the Chapter 6 protections at all. It's not right, my submission. It was a legitimate occasion for that exercise. So that's my submission about the withdrawal agreement. I think there might have been sometimes possibly a false dichotomy that suggested that we're interpreting the withdrawal agreement only and that what happens in the UK can't be an aid to that. Well, we're asking the question about how to interpret the UK's implementation of the withdrawal agreement in light of the court's understanding of the withdrawal agreement. The second point about the statutory scheme, Mr. Bewley took you to the first part of section 11 of the EU Withdrawal Act. I just want to take you back to further provision in that section, which begins at page 121. The European Union Withdrawal Act 2020. And this is Parliament's enabling provision for the remedies under Article 21, which in my submission ought therefore to be interpreted to give effect, insofar as possible, to Article 21. And Mr. Bewley already took you to language of section 11.2 F and G.
Yes.
Take you on to the language of section 11.7 over the page. For the purposes of I should say before we do that, I'm so sorry. If the bench would just look at section 11.1, the Minister of the Crown may by regulations make provisions for or in connection with appeals against citizens' rights, immigration decisions of a kind described in the regulations. And then, as we see in 11.2, the power is limited to decisions, if we look at the end of F and G, a relevant person.
Yes.
So that's the enabling power. It only relates to relevant persons in relation to those kinds of decisions. Relevant person, 7A, if Article 20 of the withdrawal agreement applies to the person. Well, my submission is that the Secretary of State's case means that Article 20 didn't apply to Mr. Molnar when the decision to deport was taken. Because no restriction had been imposed. So if she's right, these regulations would appear to be ultra vires. It's a new point. It's occurred to me as I've listened to the learned submissions of my friends, but the fact that I didn't think of it before doesn't mean it's a bad one.
Well, no. Whether you're entitled to take it is another matter. But just so I can understand it, Miss Spire, before I get it further. Just say it again.
So the point is that section 11.7 limits the power to grant the appeal rights to persons to whom Article 20 applies. Now, on the Secretary of State's case, Article 20 doesn't apply to a person until the restriction is imposed. Now, maybe that she'll tell you differently, in which case it will resolve the problem. We'll be told that Article 20 applies to Mr. Molnar before a restriction is imposed, but the right of appeal doesn't arise until the restriction is imposed. That may be one way of reading it. But in my submission, Parliament's structure of the scheme is inconsistent with the Secretary of State's contention now that the right of appeal doesn't arise when the decision to deport is made. Because Parliament appears to have envisaged that a decision to deport would be being made in respect of a person to whom Article 20 applies. I don't say it's ultra vires, of course, I say it's intra vires. The point made in our skeleton argument, which fits with this, is that the Secretary of State's case is in essence that she hasn't yet made a lawful decision to deport, which is why the language that she uses and the language in the decision in Vargova havers around that term, because what she's required to make under the law for the right of appeal to arise is a decision to deport, not a decision that she's minded to deport or a decision to consider making a deportation order. It's a decision to deport.
Where's the decision in your case?
The decision in our case, my lord, is at page 168 of
Your core bundle.
our core bundle.
Yeah.
And it is in form, at least if one starts, perhaps ends with the heading, a decision to deport. That's what the heading says.
Yeah.
And then, but in the body of the decision, it says deportation decision. And then it says, if we look 2/3 of the way down, section 32(5), Secretary of State must make a deportation order unless one or more of the exceptions applies. You've not shown any of them applies. Of course, the Secretary of State hadn't given Mr. Molnar any chance to show the exceptions applied when she made this decision. The deportation of a foreign criminal is conducive to the public good. I mean, at this point, it all gets rather murky in my submission. One might expect that then concludes, and therefore I've decided to make a deportation order against you. But then it continues, if a deportation order is made against you, these things will happen. And then over the page at 169, we get confirmation that the Secretary of State hasn't given any consideration to Mr. Molnar's case, because the only fact that she says that's taken into account, not known when you entered the United Kingdom, granted indefinite leave to remain. So we see in the body of the decision language which suggests that she hasn't made her mind up at all about what she's going to do with Mr. Molnar. She recognises she hasn't given him a chance to reply. But nevertheless, it carries on its face at the head of it the formality of a decision to deport. Which is why when we get to disposal, I will say the first tier tribunal judge was quite right to allow the appeal outright and tell the Secretary of State to start again, because she hadn't in substance she hadn't made a lawful decision to deport. She hadn't thought about whether
Well,
or
this
not
is, in the body, it's called a deportation decision, isn't it?
it is.
Under right of appeal.
Yes.
It's a right of appeal against this deportation decision.
Yes, but when we look at the reasoning, it's not apparent that the Secretary of State's actually concluded that Mr. Molnar should be deported. Could be, can be, but not should be. Because it's also accompanied by a notice to tell us why he shouldn't be deported. We can, I mean, I can make longer submissions about what we say has happened here. I mean, in short, what the Secretary of State has done is rushed through decisions at too early a stage of the process, which is merely considered liability to deportation, in order that she can label them as decisions to deport, and then said that she doesn't want a right of appeal to arise from that because she hasn't actually thought about the process. But the court doesn't necessarily need to delve into that. All the court needs to do is to say whether or not there is a right of appeal, and then, in my submission, leave it up to the first tier tribunal to work out which cases the Secretary of State has done her job and in which she hasn't. But this is a case where the first tier tribunal decided she hadn't.
Right.
The last point on decisions to deport is that set out in our skeleton argument, which my Lord Justice Paper has referred, which is the history of the decision to deport being a normal occasion for an appeal of this kind, which supports the contention that this is when the appeal right arises, and that's in our skeleton. I won't repeat it. My next point will be to turn to ground 2. I wonder if that's convenient.
It feels to me that would be a good point to stop, Mr. Cox. So we'll rise now. Thank you very much. I think we're on track this slide. Well, thank you all very much. Look forward to seeing you at 10:30 tomorrow morning.
My Lord, the court knows, I think, that I won't be attending.
We won't need to. Yes. Well, no. Well, thank you very much, Mr. Booth. We're very grateful to you, and to both interveners. Whether or not we accept their arguments is another matter. But we've been greatly assisted by your contribution. Thank you very much.